have a Q&A round table at the end when we can all talk a little more broad-rangingly about these subjects. I think that the most striking thing about the state of the death penalty in our country today is the influence that wrongful conviction is still having on the public in terms of their attitude about capital punishment. The Supreme Court decided a number of death penalty cases last term, but three of the most important, Holmes versus South Carolina, House versus Bell, and Kansas versus Marsh, involved questions about wrongful conviction. Two of them explicitly. The Holmes case was a death penalty case in which the defendant had wanted to present evidence at his trial pointing to someone else as the real killer, and the trial judge wouldn't let him present that evidence, and the South Carolina Supreme Court affirmed that. It's a very unremarkable sort of case, and not one you would normally expect the U.S. Supreme Court to take, because it's very fact-bound, it's very specific, it doesn't affect large constitutional principles. But the Supreme Court granted review in the case and unanimously held that he should have been entitled under sort of principles of fair play and due process to present this evidence that pointed to someone else as the actual suspect. And I think that is opinion written by the newest member of the Supreme Court, Justice Alito, who is likely to prove himself extremely politically conservative as the years go by. And so I think it's not insignificant that the first case he wrote was a death penalty case about innocence and about whether people may be being wrongfully convicted. The second case I mentioned, House versus Bell, is a technical ruling about death penalty appeals and when a legal issue that hasn't been properly presented to the state courts can be presented to the federal courts. And one of the circumstances under which a prisoner may do that is if he makes a sufficient showing of innocence. And the question in this case was whether Mr. House had made a sufficiently strong showing that he was not the killer to be allowed to proceed in federal court on some complaints about the fairness of his trial, which had been imperfectly presented at earlier stages of his appeal and might otherwise have been thrown out of court for that reason. And in a narrower decision than Holmes, but nevertheless still a strong decision with Justice Kennedy writing the court's opinion, the court held that the evidence in the case raised a serious doubt about Mr. House's guilt and required the courts to take a look at the fairness of his trial, even though there were these procedural irregularities in how he had presented his issues. So those are two cases in which the court sort of resoundingly says innocence is important to us in a really fundamental way. And I think those are important on their own merits. The third case that's noteworthy is Kansas versus Marsh, which on the surface doesn't have anything to do with innocence. Kansas against Marsh was a case involving the Kansas death penalty law, which instructed jurors to balance, in the process of deciding whether to impose death or life imprisonment, to balance what the statute calls the aggravating factors against the mitigating factors, the things that are really bad about the crime versus the things that might call for mercy. And what the statute told the jurors was, if the aggravation is weightier, then you should impose death. If the mitigation is weightier, you should impose life. And if they are in equipoise, if you can't decide which one weighs more, then you have to impose death. And that raised this, really troubling question about whether, in a case where the state had not proven that death was the sort of morally appropriate sentence, people would nevertheless be sentenced to death. And sadly for our movement, Mr. Marsh lost that case 5-4. The Supreme Court basically comes down on the side of saying it's up to the states to decide whether the tie goes to the hangman or not. But the interesting thing about the case from the question of innocence is that the concurring and dissenting opinions talk a lot about innocence. And basically Justice Souter, who writes the dissent for 4 members of the court, says, the reason we need to structure our death penalty laws so that the presumption is always against death. The sort of background assumption is always going to be that people should get something less than the death penalty. And the reason he says that is because he says the system is so incredibly flawed that we shouldn't design it so that death becomes the sort of default sentence when there are all these problems. There's racism in the system, there's class bias in the system, and there are problems with wrongful conviction. And he mentions a number of exoneration cases. Justice Scalia was sufficiently, he rose to this bait, I think not just because of his temperament, but because he recognizes that the question of wrongful conviction is a very potent argument against the death penalty. and that where people are genuinely concerned that we are convicting and condemning innocent people, they will be more reluctant to impose the death penalty. So Scalia really came out of the blocks, writes a hugely intemperate, searing, concurring opinion that basically denounces the idea that anyone could possibly be wrongfully convicted, and that even the people who have been released as wrongfully convicted and exonerated, they were probably all guilty too. So it's really a lively exchange of views, given that the legal issue presented by the case has nothing to do with innocence. It's about sentencing. But it's clear that everybody around the death penalty understands that the question of wrongful conviction is sort of the radioactive issue that's sort of radiating this force around this subject, so that people are thinking, maybe we should decide whether or not to have the death penalty based on how reliable you think our system is. And just in terms of sheer numbers, many of you probably know this, but there are about 3,700 people on death row in the United States. If you think our criminal justice system is 99% accurate, it's the right guy 99% of the time, that's still 37 innocent people scattered around the country awaiting execution, unless somebody proves their innocence and gets them out of custody. And if you, like me, you think the criminal justice system may be significantly less reliable than 99% accurate, then you can do the math yourself. But the numbers shoot up fairly quickly into a range where they should make us all pretty uncomfortable. So I think that the popular support for the death penalty continues to be conditional on a belief that wrongful convictions are possibly taking place. Consistent with that, I wanted to note for you that the rate of death sentencing in the U.S. is declining steadily, and has been since about 1996. So we are in really the 10th year of a demonstrable pattern of fewer and fewer death sentences being imposed around the country every year. And it's not just nationally. This isn't just a matter of sort of averaging all the states. Even here in Texas, the number of death sentences is going down every year. In Harris County in 1996, 11 people were sentenced to death that year. Last year in Harris County, only 2 people were sentenced to death. And so there definitely is a reduction over time in the popularity of capital punishment. Why that is open to a lot of debate. Among other reasons, people have again suggested that concern about innocence may be driving that. Another thing that has been attributed to that is the growth of life without parole as a sentencing alternative. In other words, where juries have the alternative of sentencing someone to be locked up basically for the rest of that person's natural life, they are less likely to pick the death penalty. And I have a lot of concerns about life without parole for obvious humanitarian reasons, but I also think that as we try to get the death, if we're trying to get the death penalty abolished first and then worry about other human rights violations, that the life without parole as a sentencing alternative has a great deal of value and really commends itself as an alternative. We'll have to see where that goes. The other thing that's been suggested is that death sentences are declining because the quality of defense lawyer representation is getting better. And I think that that is true. It's not overwhelmingly true, and that's not becoming true fast enough or in enough places in the country, because there are certainly still cases of terrible, terrible performance by defense lawyers. But I think on balance, even in Texas, the quality of defense representation in death penalty trials is improving, and that is going to have an obvious effect on the number of death sentences. There will be fewer people condemned as there are better lawyers handling their cases at trial. The next step for abolition, nobody knows. The last 2 steps forward that we made, the big significant public steps, as you all know, were the abolition in 2002 of the death penalty for people with mental retardation and the abolition in 2005 of the death penalty for juveniles. Those are, relatively speaking, easier steps to take than the next step. And what a lot of people in the legal community working against the death penalty think may be the next step is trying to outlaw the death penalty for people who are seriously mentally ill. Part of the reason that is difficult is because mental retardation, you'll hear a lot of prosecutors say that it's easy to fake being mentally retarded, and that's simply not true.